Good morning, ladies and gentlemen. My name is Adeze Anyodo. I am from Nigeria, where I'm qualified to practice as a barrister and solicitor of the Supreme Court. I have an LLM in International Commercial Law from the University of Sussex, and I'm currently a doctoral candidate of law at the University of Manchester, where I hope to major in International Investment Law. I am also the Executive Director of Women in International Law Network, otherwise known as WILNET. This lecture is in honor of Professor Gillian White, who was born on 1936 and passed away on 2016. This is a memorial lecture series inaugurated after her death in August 2016 by the School of Law at Manchester to remember Professor White, who was a distinguished member of the school, and her contribution to international economic law. Professor White obtained a first-class Bachelor of Laws degree from King's College London. This was an achievement as she attended classes as an evening student while working as an assistant examiner in the Estate Duty Office. She then proceeded to study for her Doctor of Philosophy, which she was awarded by the University of London and was also admitted to Gray's Inn. After a spell at Cambridge, where she was a research fellow in law and director of legal studies at New Hall, she then moved to the University of Manchester, where she spent the remainder of her career. Appointed as lecturer in 1967, she was appointed to senior lecturer in 1971 and to reader in 1973, before succeeding Ben Watley as professor of international law in 1975. This was a significant appointment on the part of Manchester. Gillian White was the first woman appointed as a professor in law in mainland Britain, and the first as a professor of international law in the United Kingdom. Professor White subsequently acted as dean and head of department at Manchester for a number of years, before retiring in 1991. On her appointment, Gillian White continued a line of distinguished international lawyers at Manchester, but one of her enduring legacies was the inauguration in the 1970s of a monograph series, The Million Scale Studies in International Law, published by Manchester University Press. This series has hosted the publication of groundbreaking works, including Chazournes and Christine Chinkin's The Boundaries of International Law, a feminist analysis, which was the focus of the opening session of this conference. Professor White researched fairly widely in international law, but her specialist expertise focused on two specific and then under-researched areas: the use of experts by international tribunals, and more importantly, international economic law. The latter became her domain, and her work in this area was an achievement which Dame Rosalind Higgins has described as being in that era daunting and pioneering. Professor White wrote extensively on trade law, investment law, and international monetary law, much more than she did on general international law. Professor White's contribution to the development of this field was enormous. She was one of the very few academics in the UK to carve out the province of international economic law. A convinced multilateralist, Professor White was at the forefront of the development of international economic law as we know today. For instance, she strongly defended the rule-based working trading system. In her extensive scholarship on GATT, General Agreements on Trade and Tariff, and WTO, Dispute Settlement Practice, Professor White developed an account of treaty interpretation of international trade rules, which set the pace for the international legal scholarship that followed. Gillian White married an Australian farmer, Colin Fraser, in her early 30s. They lived in England before moving to Australia after she retired, where she was instrumental in supporting a palliative care facility in Tamworth, the town to where she and her husband had retired. It is fitting that it was there where she ended her days. Professor Gillian White was a groundbreaker, a pioneering woman academic who inspired colleagues over decades. To celebrate her legacy, the Manchester International Law Center, with the general support of the School of Law, has established the annual public lecture in her name. The inaugural lecture was delivered by Professor Mary Footer of the University of Nottingham in March 2017, while the second lecture will be delivered today by Professor Laurence, Boisson de Chazournes. of the University of Geneva. Fittingly, the Gillian White Lecture is administered by the Center's Women in International Law Network, which has the aim of providing a professional community for women international lawyers at all stages of their careers. Professor Boisson, the Chazournes lecture will be introduced by Professor Nkonkodu, who is a professor of international economic law at Manchester and also my research supervisor. Please welcome Professor Nkonkodu.
Thank you, Daisy. Good afternoon, ladies and gentlemen. And I want to thank my colleagues, Professor Dapromont, Professor Jan Scobie, and all the Milk family that have contributed to the success, I hope success, of this conference. We want to believe that it is a success. I want to thank you very much, and of course, I want to thank the audience for participating in the conference. What a heavy 3 days. So now, I'm supposed just to briefly introduce our speaker today, our star of today. But I have some very few remarks here to make with regards to the theme of the conference. I'll be very brief. I know that we don't have much time here. So international economic law since the post-war era has somehow been a laboratory of universality. That is what we want to believe. Universalism, or at least attempt to universalize international economic law, has been more visible in some of the areas of international economic laws than others. For instance, while in the area of international investment law, monetary law, tax law, universality is very much alien and is at best present in the form of some highly contested principles. Universalism has somehow been inbuilt in international trade law. From the failed Havana Charter to the advent of GATT-WTO, there has always been an attempt, either in the form of differentiation or through the most favored nation or national treatment principle to universalize international trade law. Yet, the quest for universalism seems to be precipitating the obituary of the GATT-WTO as what has been considered as the last avatar of universality. If the dominant idea seemed to celebrate the fall of the Soviet Empire and its satellites as a key moment that led to the conclusion of a universal international trade rules, now that universalism is fast ebbing away from that very structure, one is tempted to ask these very few questions. I know we started the conference with a lot of questions for contestation. Do we need a collapse of another ideological empire to reinvigorate universality in international economic law? If so, what kind of universality are we really talking about here? Third, is universality a mere utopia or myth in international economic law? Ou l'universalité est-elle une malédiction en droit économique international? Or is universality just an undesirable phenomenon in a world of populism? There is no better person to respond or even contest this question than my able sister, Professor Laurence Boisson de Chazournes. I know that you prefer that I leave it at this level in terms of introduction, but I think I will not be doing justice to many of us that you have mentored if I leave it at this level. I'm just going to say a fraction of your contribution to the field of international economic law and international law in general, as well as the practice. Laurence is a professor of international law at the University of Geneva School of Law. Her writings and practice cover a broad spectrum of international law, such as international economic law, international environmental law, international dispute settlement, and the law of international organization. She is a recognized practitioner for her role as an advisor to many international organizations, states, and non-state entities, both public and private, as well as arbitrators and counsel in various dispute settlement fora, including the ICJ, WTO, ICSID, and so on, Permanent Court of Arbitration. The list goes on. Some of our recent works include interaction between regional and universal organization, a legal perspective, which I'm proud and honored to say I've just received a copy now. Thank you very much for that, Laurence. And this recent book, published in 2016 by Brill, has received a lot of positive reviews. And then the other one in 2013 was Freshwater in International Law, which has also been very much reviewed. Yeah, I know Laurence wouldn't want me to go too far, but it suffices to also say that she's also more scholar than practitioner, although she has been very much involved in the practice of international economic law. Alors, Laurence, merci d'avoir accepté notre invitation. Lorsque je vous ai demandé de prononcer cette conférence, vous n'avez pas hésité à dire oui. Vous avez la parole, ma sœur.
Thank you very much. It's a pleasure to be here today and to be so warmly welcomed by good friends, Jean, Yan, and Yang Kong. And I must say that I'm also very touched to have been invited to give a lecture in the context of an annual conference of the European Society of International Law. I'm going to say a secret, but I think it's my preferred society of international lawyers. So, we have discussed a lot about universality and the contest about universality during these last 3 days. So today I'm going to be concentrating on international economic law and universality. Possibly, can we speak of universality in the context of international economic law? And I'm going to be looking at universality from what I call a normative standpoint. I'm going to be looking at the rules and not really at the institutions. And as we all know, during this last 3 days, we can have various definitions of universality, and I think we can have another conference of the European Society dedicated to universality. And in this context, I think that there are several definitions that I would like to highlight. The one would be that universality means that law is omnipresent. That means that law would apply to all states. Okay? And I take the number of states of the United Nations. Now, there is another acception of universality from a normative standpoint, and it's when you look at normativity and see if we have a body of norms which could be qualified as a coherent legal system. And so when we look at this type of universality, we look at the law as a system, and it implies generality. So it's another acception that I would like to give about on the meaning of universality. There is another meaning of universality from a normative standpoint. It's when universality has the ambit to create a global public order. And that, I think, it's an entirely different conception of universality, because there, when we speak of universality, it's we're speaking of a value-oriented system promoting collective interest, or if we speak in economic terms, global public goods. Now, just as way of introduction for this conference, I don't think that we can speak of such a conception of universality in the field of international economic law. I feel that, and you will see that we may be speaking of universality as omnipresent, of law as omnipresent, and universality as a generality. But if we want to use these terms, as we know, and we've discussed that, you need to have possibility of variances and deviations. And so from the angle of treaty law, you need to have the possibility, for example, to do reservations and so on, so that you have flexibility tools. Now, treaties, yes, and you're going to see that they play a crucial role in international economic law. But I think that we should not forget that customary international law is also a vehicle for promoting universal law. And if you look at the definition of customary international law that we have in the statute of the International Court of Justice, a general practice accepted as law, I think that there is the potential that we could equate universality with the customary law with universality as omnipresence. And there too, we have variances mechanisms such as the persistent objector, regional customs, and so on. Now, if we implement these notions in the context of international economic law, let me start by saying that, in fact, the pursuit of universality in international economic law has been a long and tumultuous relationship. And it started as the end of the 19th century with the Industrial Revolution, and it continued over in the 20th century. I think that the key moment for speaking about universality, possible universality in international economic terms, is really after the Second World War, with the establishment of the Bretton Woods institutions. They had the ambit of being universal. They became universal only in the 90s, after the fall, the dismantling of Soviet Union. So a first attempt, which was not really successful, only successful at the end of the 20th century. Now, I think there is another important time in the 70s with the new states coming on board at the United Nations and saying, we want a new international economic order. And that is the new international economic order as conceptualized in the Declaration and the Charter on Economic Rights and Duties of States. And there, what did the developing countries want? They wanted to have a global economy governed by rules which would orient the benefits of globalization towards the needs of the developing countries. As you all know, this has not been a successful attempt. So we have remains, as we will see, but not much in terms of this new orientation of the international economic order. Rather, what we have seen with decolonization, with Cold War, with political interest and so on, is that we've seen that states have taken a pragmatic approach to their relationships in international economic terms, and they have privileged bilateral treaties, regional treaties, multilateral treaties, and very rarely they are focused on universalism. So that's the point that I would like to stress. Now, when I'm going to be highlighting this, I'm going to be focusing on international trade law, and I'm going to be focusing on international investment law. I'm not going to be speaking about financial law. The thing is that I don't know much about it, I must say, but also I think, having glanced through a lot of the readings, it seems to me that we can't speak of universality in this field. So let's start with international trade law. Oh, sorry. I wanted to speak about it. And that's before we speak about trade law and investment law, I also would like to give a few words about customary international law. Because when we will be speaking of investment law and trade law, we will be speaking mostly about treaties. But can we speak about customary international law in the field of international economic law? And this is very interesting because one of the key principles of international economic law is the principle of sovereignty over natural resources and economic activities which are related to the exploitation, the use of natural resources. So we have an important principle. We have another principle which I think is a limitation to the state immunity in respect of economic transactions. And maybe we have another principle which is related to the minimum standard of treatment. But that means that we don't have much in terms of customary international law. And that's a point that I would like to stress, is that states have been very reluctant to admit that customary international law could sort of codify and develop international economic law. And I want to take as an example the work of the International Law Commission. We celebrated the 70th anniversary of the International Law Commission in Geneva in in July. When you look at the agenda of the International Law Commission, you will see that there are very few topics related to international economic law. And when I looked at the topics that they had touched upon, for example, the MFN, the most favored nation principle, in the 70s and then in the early 2000s, you'll see that they didn't do much. And in fact, they left it to the states to decide what they wanted to do with this principle. So they sort of codified the main approaches to the MFN principle. There was another topic, economic topic, that was brought to the attention of the Commission, which deals with shared natural resources. And when the topic was put on the agenda of the Commission, it was to cover groundwaters, but it was also to cover oil and gas. The working group of the Commission worked for 3 years, and at the end, in 2010, they decided that it was better to focus on groundwaters and to leave oil and gas, shared natural resources such as oil and gas, outside of the ambit of the Commission, and they said that it was too politically sensitive, so they don't want to touch upon that. Now, if you look at what the Institut de Droit International has done in terms of economic law, you will see that there is not much. The Institute is starting to work on investment law, but we are really at the starting point. That means that in the field of international economic law, and that's the point that I want to make, that there is a primary source, which is treaty. And customary international law doesn't have much to say, except if we put aside the principle of sovereignty, which is, as I say, the cornerstone principle. So now let's really turn to trade. And as I don't see well, I think it's the trade slide which is there. Okay. So the case of trade, there we are entering in a specific story. It's a case study. As I will call it, it's an inbuilt quasi-universality, which has been shaped over time. It has been tough, and we had a presentation in the context of this conference about the International Trade Organization, the Havana Charter, which was negotiated and adopted by 64 countries, but which never entered into force. So we had in year and place of the Havana Charter, the GATT, as an institution which developed over time, but it was not a universal grouping of states. It was a club of states shaping the rules in terms of trade of goods. And then really the milestone for sort of asserting universality in the trade field was the transformation of the GATT in the WTO in 1995. So we have what I've called an inbuilt quasi-universality system. Quasi-universality because it has 164 member states, okay? But if we look at the volume of trade which is covered by these 164 states, it's about 98% of the world's trade. So from an economic perspective, I think that we can bring a universality dimension. Now, why do I speak of inbuilt universality? Because there are a series of features which have been used to build this universality. So, first of all, there was this idea that protectionism between the two world wars had caused a lot of problems, so there was a need to promote non-discrimination. So non-discrimination in various forms is the key principle in this system. Then with the WTO, there is a new technique which has been used, which is the single undertaking. Single undertaking means that it applied to all the members which created the WTO. It also applies to the new WTO members. And it means that if you become a member of the WTO, you have to accept the whole package. You can't just discuss, and reservations are prohibited. So that means that the universality is constrained, okay, through the accession. And then there is another feature I will come back to, which is important, it's consensus. Everything is adopted through consensus. So there is no possibility of deviation with majority voting because that has not been put in practice in the context of the WTO. So we have these features. Now, there are also other specificities which are, I think, prices that were paid to these inbuilt universalities. First of all, there is, and I'm going to take a notion that was used by the late John Jackson about the GATT. It's the GATT and the WTO have constituted an interface mechanism that permits international trade between countries having different economies. So the system allows for different economies to coexist, but they should abide themselves to the same rules. And the key point for making these different economies accessing to this forum is through accession. So you also had a presentation about the issue of accession by China to the WTO in 2003. And those who are interested in protocol of accessions, you should look at this one. It's a huge package of conditions. At that time, the United States and the others were thinking that they could change the economic system of China, so China would become a real member of the WTO. You all know that one of the main bone of contentions of today is the fact that there are a lot of criticism about the way China is running its economy, and especially the treatment of state-owned enterprises and the fact that there are a lot of subsidies, which are disguised subsidies in the context of trade. So this interface mechanism, that's a way to build this inbuilt universality. The other tool that I think is important, and Yan Kong referred to it, is that regionalism has its place in the context of WTO. You have a provision in the GATT Article 24, which says that trade agreements, regional trade agreements, can be concluded. And at the beginning, when they included this, they thought that it would be complementary to universal liberalization. In fact, and I'll be brief on that, and we can come back to that in the discussion, they were thinking that it could be an oversight, and we could control regionalism. Regionalism today is no more complementary. Regionalism is competing the universal dimension of WTO. And I'm also stressing that because we're not speaking of only regional agreements like NAFTA. We're now speaking of mega regional trade agreements, okay, which are in fact including provisions that can't be negotiated at the WTO because there is a stalemate, there is a blocking of the negotiation process in the Universal Forum. So in this context, the Universal Forum, the inbuilt universality, is challenged more and more by the regional dimension. Third element to constrain this inbuilt universality is the fact that, yes, we take into account the differences in terms of the economies of the different countries. But we can't deny that we have the South, we have the North, and especially after the decolonization. And so the developing countries which became parties to the WTO very early on asked for special and differentiated treatments so that their needs could be taken into account in the context of the GATT and then the WTO. And this special and differential treatment has been enshrined in the law of the WTO, and especially through the Doha Declaration of 2001. Now, as you see, it's an inbuilt universality, quasi-universality system. It's an inbuilt universality system which is making place to particularities and specificities. And that's the first point that I would like to make, is that we need to take into account these particularities and differentiations. And we lawyers, we have the tool for adjusting these realities to the universal context. And I think that in this context, if we leave space for differentiation, we can speak of the WTO as a universal system in terms of generality. And it's quite interesting to take into account that the latest agreement that has been negotiated at WTO, the WTO agreement on trade facilitation, is really an instrument which is leaving space to all the countries, not just the southern countries, but all the countries. There is space for differentiation. Now, so I've presented the tools for forging this, constraining this universality. 2 points in conclusions about the trade system is that these elements for forging the universality are now a threat to the universality. And we all follow what is going on in Geneva, but the consensus is a threat to universality. Nothing has happened since the early 2000s in terms of negotiations, except this agreement on trade facilitation. Okay, so blocking. Blocking, and it's not just the Western countries and the US, it's also the Southern countries, it's India, and so on. So that's one element, but it goes very far today. For us lawyers, I think it's a big concern, is that this consensus is also blocking the reappointment or the appointment of members of the appellate body at the WTO. That means that at the end of 2019, it might be that we're no more going to have an appellate body because the consensus doesn't help to appoint, and the US is against the appointment, has positioned itself as being against the appointment of the several members which were running for re-election. The other threat that I've already highlighted is that we left space, our grandfathers, fathers and mothers, there were not many mothers when I look at the pictures in the 40s, left space for trade, for regional agreements. Because this was a practice. Nowadays, as I've said, regionalism has become a threat to universalism in the field of trade. So that is for trade. Now, let's move to investment law. So investment law is totally different from international trade law. When we speak of investment law, we speak of a decentralized system. We speak of a decentralized system which is constituted by a web of bilateral investment agreements and a few regional agreements, such as, for example, the Energy Charter. And there have been certain attempts to universalize investment law through the OECD, which had the pretension of being a universal organization which could shape the world of investment law. The OECD made two attempts, one in the 60s, and there was a draft convention adopted in 67. It didn't go along, there was no acceptance of it. And then there was an attempt at the end of the 90s to have a new international convention dealing with investment law, but there too, a failure, it didn't go ahead. So that means that we don't have multilateral instruments which can have the possibility of becoming universal organizations. I'm purposely putting aside the ICSID Convention, the Washington Convention, because the Washington Convention is only dealing with procedural matters, with dispute settlement issues. Okay. So in terms of norms, in terms of substantive standards, the only law that we have are about 3,000 bilateral investment treaties, and I said a few regional treaties. Now, does it mean that we can't speak of universality because we have this web of bilateral system? I don't really think so, because what is interesting is that law is omnipresent. What do I say by that? I think that I'd like to highlight that almost all countries have signed at least one bilateral investment treaty, and many countries are parties to numerous bilateral investment treaties. So the system is atomized because we have various bilateral treaties, but the system doesn't have legal coherence. We can't speak of generality as I have defined it, but we can speak of omnipresence of the law. Now, we have colleagues who have written a lot about, in fact, the fact that even if we have bilateral treaties, we have a universal system. And why do they say that? They say, but look at the bilateral investment treaties. They all look alike. And there is an emulation process which is going on. So in a way, there is a coalescence of meaning of the main standards of investment law. Yes and no, because more and more if you look at the way states are renegotiating their treaties, and I'm thinking of the African countries, they don't want any more of these traditional standards. They want standards that they can format according to their needs. So I think that is something, but some are saying, even though you have a lot of commonalities. And one element which is also raised by the colleagues who are speaking of universality is that they say we have a body of jurisprudence, the case law. The arbitral tribunals, they have rendered the decisions, and it's part of investment law. And I have a lot of question about this assertion, because I think that, like in the context of trade, it's not for arbitrators to be shaping investment law, it's for the states to be negotiating it in transparency with the non-state actors who are interested. So that's the system. Now, there are a few discussions, and I'm looking at my watch, and I'm not going to be too long. But there are a few features that can be resorted to, that have been used by some to say, but we have tools for universalizing the investment law. And so the first tool that is often referred to is the most favored nation principle. And they are saying, with the most favored nation principle, you can extend standards which are incorporated in some treaties to other treaties. Now, we're not going to enter into the discussion about the scope of the application of the most favored nations. Remember that the International Law Commission said that there was no space for codification. That means there's a lot of differences in terms of approaches to how the MFN can be implemented in the investment field. But you have tribunals which went as far as to incorporate standards from other treaties in a treaty, even though the treaty was not dealing with a specific issue. Let's say expropriation, a treaty that they have to interpret is not dealing with expropriation. The arbitral tribunal, with the support of the parties, or one party, incorporate a provision about expropriation which pertains to another treaty. And they say this is going to universalize international law and the meaning of these standards. I have serious doubts, and I'd like to make a distinction with the trade law, the WTO, because in the context of the WTO, we have the MFN. But it's a principle that has been agreed upon by all states when they became members of the WTO. So it's agreed upon, and they know that it's going to play, and it's in an institutional forum which is organizing the relationships between the states. Now, are there other ways to speak about universalization of investment law? I just wanted to, I looked at some recent attempts, and there have been, in the context of ancestral, various attempts to sort of multilateralize and try to go towards universality. And there is a convention that has been adopted in 2014 on transparency in treaty-based investor-state arbitration issues. That means that the civil society is asking for transparency, and the states have accepted to negotiate a convention whereby there will be a possibility of producing amicus curiae, there will be a possibility of accessing to the memorials of the parties, and the possibility to be there when the parties are pleading. So we can say, yeah, now we're going to have this multilateral treaty which has been negotiated in a universal forum. When you look at the numbers of parties, there are 4, and 23 countries have signed it. I really doubt that it has entered into force because we needed 3 countries. Okay, so it has entered into force. But I don't think it's going to. It has the potentiality of becoming a universal treaty. I'm not so sure that the states want it to become an instrument of reference in terms of transparency. Nowadays, there are also discussions at UNCITRAL with respect to dispute settlement. You all know the discussions about the arbitration, which is secretive, which is non-transparent, which is arbitrary, and the need for, suppose, your court or the need for domestic dispute settlement mechanisms to play a role in investment disputes. So UNCITRAL has taken this topic on board. Now, it's interesting, and there are people in this room who have written about this. What is interesting is that, yes, we see that states, there are some states who want to reform drastically the system, others who just want to make some cosmetic arrangements and so on. But what we're going to have, my sense, is that we're not going to have a universally unique system. We might have a universal scheme with plurality and differentiation. Okay? So that means that some states, like the EU members and other states, are going to favor the establishment of a court. Others are going to favor another type of mechanism. There are a lot of stress which is put on diplomatic mechanisms for resolving investment disputes and so on. So there, even if we have an attempt to discuss in a universal forum about an important topic, what we see is that already differentiation is there. And pluralism has become a key buzzword for qualifying what might be achieved through this forum. So in terms of concluding remarks with respect to universality in the field of international economic law, I'd like to say, to say a few things. Is that yes, we have science of universality, but you see that science of universality, that can only work in an institutionalized forum if we think of trade, okay? But if we think about the trade story, we realize that there are a lot of threats going on, and it's not sure that it's a system which is going to survive the attacks of some countries. So there is something to be said about this non-willingness of keeping this universality system in the trade field. When we speak about trade, we spoke about the fact that there is a need for differentiation. Now, the question is that, are the differentiation tools that I have exposed sufficient for allowing universality to survive in the trade field? And I'm looking at Yan Kong because there are more and more countries which are now attacking the special and differential treatment of developing countries at the WTO, saying, well, why? Why? In the 21st century, we should still have this distinction, and so on. So it doesn't mean that this form of differentiation is going to survive. Now, if we look at the investment area, there we don't have any forum, common forum, apart ancestral, but I don't really consider that it's the forum that we need for political matters such as investment protection. So should we need a new forum? But even if we have a universal forum for investment protection, my bet is that we're going to design a system which is going to be living on pluralism and differentiation. So it would be a special type of universality. And all that brings me to something that you can read on the PowerPoint. I think it's very interesting to realize that there have been various attempts at universality, but the signal is that states want to remain in control. I'm not saying that they're controlling the economic system. That's another story. They want to control the economic legal system. Okay? And we can see that for the time being, it's really pragmatic solutions which have emerged. And we see also that there are a lot of political considerations which are at stake for states. And today, we have one of the big economic actor, which is saying unilateralism is the way to promote international trade interest, okay? So it's against this universality idea that has been promoted since the 1940s. Now, the question, and I don't have an answer, but the question when preparing this lecture, I was wondering, but maybe it's also because it's about the meaning of international economic law. You see, I spoke of trade, I spoke of investment, but can we delink trade and investment law from other concerns? What we call the collective preferences, labor issues, environmental issues, and so on. And that brings me to say that maybe that there is need for more inclusivity in the economic sphere, more inclusivity and maybe more equity, but a different form of equity than the one that we have designed so far. So the thinking that I have currently, that if we think about developing universality, we have to rethink the parameters of why we want economic international law to be implemented the way we have shaped it in the last century. Thank you for your attention.
Thank you very much for the talk, Laurence. You always inspire me when you give your lecture, and you haven't disappointed me in that regard. Thank you. Now, I think we have about 15 minutes for question and answer. But before that, maybe I just make these remarks. Jean Tick started this conference with a series of questions on universality. And the good news is that we actually kind of ending the conference also with a series of questions, which means that for us, we are happy because it means it's been a good conference because there was academic debate would always have questions without answer or possibly the answer that will be suggested at a later time. So I will take series of questions for Laurence, and then any questions, please, and introduce yourself, and then you can ask your question very briefly, please. Yes, we have a question from that lady.
Elisa Baroncini from the University of Bologna. Well, thank you, Professor, for the excellent overview that you gave us on universality and international economic law. If I may try to introduce a positive remark or a weak sign of hope, I would like to underline, with reference to trade, to the multilateral trade system, some elements that, if we are taken as point of possible strength, could be further developed in order to provide, as lawyers, possible solution to keep and improve the system. If we take into consideration the regional trade agreements, the new generation of mega regionals, we always find in the institutional parts different provisions that are devoted to the fact that these mega regionals have to be read, interpreted, applied as being compatible with the WTO system. And in particular, if we take into consideration the new generation of the EU free trade agreements, for instance CETA, not only they say that WTO law has to be considered having a value of primacy by comparison to the mega regionals, but also the case law of the expressed of the WTO dispute settlement mechanism has to be taken into consideration by the regional trade dispute settlement mechanism. So if we give strength to these principles, I mean, it's a recognition of the importance of the universal value of the WTO system, which is able to guarantee also diversity because of the exception clauses, of the possibility to have free trade agreements, and so on and so forth. Maybe it's a point of strength that we as technicians can offer to the political pillar that seems to be a little bit weak in this moment, or to civil society that seems to be worried by global economy that cannot be stopped but needs rules of fairness in order to guarantee equilibrium. Maybe it's a point of strength. For the United States, the moment is really difficult, I think. But at the same time, in this very difficult moment, they keep presenting cases to the WTO dispute settlement system. And when they enact any sort of unilateral measure, they deserve quite a significant part of their efforts to demonstrate that it is compatible with the WTO system. So I think that...
Okay, thank you, Valentina. You have Jan that way, yeah.
Thanks. Thought I'd let you not run around the whole room. Two questions, Laurence, relatively brief, I guess. Thank you for a wonderful talk. The first one, the title speaks of the curse of universality, and you end up talking a little bit about your international economic law between curse and hope. But why is universality a curse? I didn't quite get that. Second question, there are people who say that the structure of economic life is changing, that the economies are fundamentally getting restructured towards a platform economy, with companies like Uber and Airbnb as the lead examples, perhaps. And this is born out of ignorance. Is there any activity going on in international economic law to address the platform economy? Thank you.
Okay, thank you. We take one now. Yeah, and we'll come back. Yeah, yes, this gentleman here, please.
Thank you. Andreas Kodik, University of Tübingen. Also have two questions. My first question goes more or less to the same question as Jan Klapper's first question. Is universality, I mean, if you're talking about the universality curse, is universality the right or the wrong way to think about international economic relations? And second question, you talked about other concerns like human rights, environment, labor issues, and so on. If universality is a curse, how to address those issues? Are those issues maybe only to be addressed within the universality paradigm? Thank you very much.
Okay, thank you. Laurence, you take this one now, and then we'll go for the next round. Yeah.
Thank you very much. I think I'm a bit like Elisa. I want to be positive, and you know me. So I'm always trying to see what can help resolve the tensions between the unilateral and the regional. And one thing is that regional, we call it regional, but it means a lot of different things too. Okay. Now, I don't disapprove the fact that some regional agreements have in fact been taken into account the Universal Forum, and I've written about that, and that the EU is sort of the good student in this respect. But for me, it's not really the dispute settlement system as such which is an issue, and the conflicts of interpretations that might arise, because I think we have ways to solve these issues. But for me, it's more the fact that when you look at meager regional agreements, they are covering issues that are not covered in the context of the WTO. So maybe you can have this positive glance that you had and say, but the regional is going to bring food for thought in the context of the Universal Forum. And that could be. But I think there is an issue, because who is going to be deciding? Is it not for all states of the world to be deciding what should be the content of international trade and so on? And very often when you speak of these mega regional agreements, it's mostly the rich countries which are shaping the new international economic order. So that's my first reaction. Now, with respect to the title, and I didn't say what I wanted to say, but the title is that because it came to my mind because in fact you've seen that there have been several attempts, but they were not successful. There is something. In French, we speak of la malédiction. Okay? There is something about attempting to become universal in the international system. And the preparation of this conference allowed me to read again about what happened in the 70s. And there, the developing countries were numerous, they were powerful, they had a voice. Ambassador Bejawi was shaping international development law and so on. What is left from all this? What is left from all this? If you look at the attempts in the field of investment law, what is left from all this? So for me, the only thing which has been possible is through the WTO, because it's inbuilt and it's constrained. But in fact, what I've said is that even if we've tried to do that, there might be some problems, the consensus and the regional agreement. So that's why I used this term, which might be a bit too strong. Now, I didn't end as I wanted to, but what I wanted to say about this new way of looking at international economic law is that we've faced a curse. It's been a curse to try to develop international economic law at the universal level. Now, would it be a blessing to integrate other concerns so that maybe we could attempt to have a new international economic order which would be more integrative, more inclusive, and more equitable? I don't know, maybe it's a wishful thinking. Okay. So that was the opposition between curse and blessing. And the blessing should have been mentioned.
Okay, we'll go now for another round of questions. Yes, the gentleman.
Thank you very much for your excellent lecture. If we compare international economic law to other branches of international law, use Kogan's, human rights, laws of war, perhaps in this sphere, international economic law, it is good to have more pluralism. I mean, in light of the increasing cultural differences, ideological differences, perhaps we should tolerate much more pluralism in this sphere of international economic law. Thanks.
Okay. Yeah.
Thank you very much. Thank you, Laurent. Pierre Dargent from Louvain University. Thank you, Laurence, for this wonderful lecture. I would like to build on the question of Elisa and of Moshe. More diversity, more pluralism. It is true that the regional agreements or the free trade agreements pay homage, to a certain extent, to the WTO rules. They build from it. Simply, we do more things together. We don't do things much differently because it refers to the general rules or the WTO rules. And the issue of diversity or plurality, Moshe, is exactly that. Is there really a diversity when actually you do more but not very differently from the general rules that are still the legal background on which you build additional systems? That will certainly create some fragmentation or diversity, but intellectually it's not very diverse. It's a replication, approfondissement, but it's not radically different from what is done. Therefore, the issue of the differentiation that you raised, Laurence, is really whether the system is so different and maybe it prevents some uniformity, but it remains so much based on the same understanding of rules.
Okay, one last question. Okay, yeah, this is gentleman there. Yeah.
Malcolm Langford, the University of Oslo. So I largely agree with your evaluative assessment of universality, although if we see the new investment agreements, some of them are more pro-state, others in fact are more pro-investment. So there are divergent trends there. But I've more a question on the blessing. Is there a paradox that the most universal regimes, human rights, environment, international criminal law, are the weakest? And maybe the lack of universality is actually a blessing, because these agreements are more hardly negotiated and they may have more effect in practice because there's more consensus. So which way does blessing and curse go?
Okay, yeah.
You see, this is the difficulty when you end a conference, a speech with a question. Then it attracts other questions. And I'm going to be humble. I don't have the answers for all the queries, and I think it could be a wonderful theme for the next annual conference, the links between the bodies of norms. But what I'd like to say is that, first of all, in answer to Pierre, I think Pierre has very much in mind the CETA agreement, okay? The Canada-European Union Free Trade Agreement, okay? So that's, maybe you could consider that there is a lot of compatibility with WTO, and I think with plus elements. There may be other agreements which are negotiated these days on the other side of the Atlantic, which are not going to be at all the same, okay? So I think that I've written that. I don't think that regionalism is a bad thing. I think that regionalism I think that the WTO should accommodate regionalism. I think that the WTO has not yet developed the tools for accommodating regionalism. And then what I think is that the regional actors should also be very careful in not dismantling something that they have built over the 20th century. So that's what I wanted to say. Now, there is a question that Jan asked a question about the structure of WTO and this non-hierarchical system and so on. What I think is that one of the answers for me, but it's really one of the answers to the queries about how to link the trade, the economic law with other concerns. I call them collective preferences, but it's human rights, it's environment, it's labor law. It's also through sort of a revisiting of the relationships between international organizations. And in Geneva, there is this tendency to look at WTO for trade and not to look at other organizations for trade issues. But if you think, we had a panel yesterday about health. Health is very much about trade. It's all about traffic and so on, okay? And labor is also about trade and so on. But we don't have, us lawyers, we don't, I think, have yet the tools for having these organizations and these different groupings working together for elaborating what I call a new language in terms of international economic law. Thank you.
Okay, I think I will end here. It's only left for me to thank you very much on behalf of the University of Manchester, as well as on behalf of the Manchester International Law Centre. Thank you, Laurence. Yeah.